Next call the matter of Heather Christensen versus Joshua Brady, file number 14-15560 UN. Do we have anyone present on that matter? It does not appear that either party is present. Front of the court, what is the status of this matter?
I'm here, sir. Sorry.
All right, thank you, sir.
This hearing was adjourned from July 1st when the defendant failed to appear and to monitor specific payments towards overdue child support balance. The friend of the court is enforcing a Minnesota order that is an arrears only with a balance of $16,425.01 with a request to collect at $235 monthly. Friend of the court did have contact with the defendant yesterday as he was reporting he was starting employment next week.
Thank you. Mr. Brady, what would you like to say?
I do apologize for that. I'm currently on probation. I got a lot of paperwork. I completely missed that, and that will not happen again. I truly apologize for that, Your Honor.
All right. How about work and payments then?
I can start making payments next week. I am starting employment. I was kind of curious what is the minimum? Could I do like $20, $30 a week? Because right now I'm still living in a hotel. And when I start this job, unfortunately, I'm going to have to pay for my room because I can't work for the hotel. And that's $80 a day right there.
Well, the other state is asking to be collected at $235, so that's what I'm going with. If you want to adjust the amount, you'd have to speak to them. I would think for a balance of $16,000, that's not an unreasonable ask.
Yes, sir.
Are you a payroll or are you getting paid cash?
Cash.
All right. So obviously, it's going to be on you to make sure the payments are coming in.
Yes, sir.
I'm going to adjourn you out a little bit to make sure you're getting those payments in. You've started the job or are about to start?
I'm going to start next week, sir.
All right. I'm going to give you a little bit of a break to get on track. So I'm going to adjourn you to October 12th.
Thank you, sir.
So we're in late August, so you're not going to have a whole lot of August time, but I'm going to expect at least that September payment be made when we come back on October 12th.
It will be made, sir.
We'll have a discussion to make sure everything's moving along smooth, and what we'll do after that, if that payment's made, then obviously if not, you would be sent for a contempt hearing in front of the judge. Any questions, sir?
No, sir.
All right, thank you for showing up today. Make sure you're here October 12th, okay?
Yes, sir. Thank you. Bye.
Can you hear me okay?
Yes, sir.
And Ms. Huff, can you hear me okay?
Yes.
Thank you. In front of the court, what is the status of this matter?
This hearing was adjourned from July 1st to monitor the defendant's compliance with provisions of the stipulated order and good faith efforts to make payments and his employment status. Since the hearing, the defendant has paid $500 in July and $250 so far in August towards his support obligation of $834 with an arrears balance of $29,854.90. Our office has completed a new support recommendation that was mailed out to the parties yesterday, but they have not received that new support recommendation.
Thank you. Mr. Huff, what would you like to say?
I just want to say that I did find a full-time job. I started like 2-3 weeks ago, and I want to continue to pay good efforts and just stay out of here, you know.
All right. You expecting another payment in for this month of August?
Yes, sir. I'll have more this week, and I believe we still have a full week next week too, right? I'll have one next week. Yes. So
Right.
two.
And are you on a payroll, cash payment, W-2, W-9?
I'm 1099.
Okay. All right. So obviously that means, we can't take money directly, so it's on you to get those payments in. So we are going to expect those. Ms. Huff, anything that you would like to say or any questions that you have?
No, not at this time.
All right. Well, given that there's been some effort the last 2 months, I'm gonna adjourn you out just to make sure that that continues. It sounds like there's gonna be a potential change in the monthly support amount. But we're still gonna have to address, getting payments in and paying towards the balance. So I'm gonna adjourn you to I'll go to October 12th so we can get the rest of August and all of September and allow for that other recommendation to see where that's at. But obviously, sir, presently your current monthly obligation is 834, so you need to get as close to that as you can, or really should be there, but you need to make sure you're making an effort to get that amount in until sort of change. And then when there is a change, we'll address what the new monthly amount should be and what your payment on the back support should be. Any questions, sir?
No, sir.
Ms. Huff, any questions?
No.
All right, thank you both for appearing. You are free to sign off.
Thank you.
Next calls the matter of Naomi Keaton versus Brian Fraser, file number 20-18252GC. Do we have the parties on that matter present?
Yeah.
Fraser is here. I have Ms. Keaton present. Front of the court, what is the status of this matter?
This hearing was adjourned from July 1st to monitor the plaintiff's employment status, and if employed, plaintiff was to contact front of the court and provide any requested information necessary to ensure withholding. Front of the court is in the process of a support review after the plaintiff's release from incarceration. So as of now, there's an overdue support balance of $4,320.52. Employment status was updated for the plaintiff on August 7th, and an income withholding was generated to collect towards the overdue support balance. It does appear that payments have been being collected, but being applied to a currently charging case in another county.
All right, thank you, sir. Anything that you would like to say?
No, I mean, she said it all, but thank you.
All right, well, if there is some employment, I'm not gonna do a bench warrant today. I'll allow that support review to happen and see what kind of payments, if any, get in, and then we'll address obviously the issue at that time if there are no payments. I'm gonna
Yeah.
adjourn to October 12th to monitor those situations, and obviously if we come back October 12th and there's no payments and she's not present, there will be a bench warrant.
She is
Our
present,
payments-
but is not present today. Oh, sorry, sir.
Go ahead.
Is she present today?
She's not.
Oh, that's the last.
Given
She wasn't here for our or whatever parenting time either.
Right. Yeah.
So that's weird.
Give-
But all right.
Some income, I'll give her a chance to show up October 12th, and then we'll see if there's been any payments through that new job, but if that new job even still is ongoing. So we'll adjourn to
Yeah.
October. All right, thank you for appearing, sir. You are free to sign off. Matter of Ronald Martin versus Cassandra Ingersoll, file number 03-10173 DM. Anyone present on that case? Appear that either party is present. Front of the court, what is the status of this matter?
This is an arrears only case, and the plaintiff has a current balance of $13,112.33, with the last payment being received in March of 26 in the amount of $94.86. I have not had any luck getting in contact with either party.
Thank you. Due to failure to appear, I will recommend a bench warrant amount of $3,300 plus $100 in costs. Owens versus Thomas Lair, file number 11-13887DS. Do we have the parties on that matter present?
Yes, sir.
Thank you.
Yes.
Thank you. Both parties are present. Front of the court, what is the status of this matter?
The defendant has a support obligation of $14 plus an additional $50 ordered on arrears. The current balance is $1,634.72. The defendant did make a $350 payment this month. However, the reason we have not canceled this hearing today is because of the history of Mr. Lear only making payments when there is a show cause notice sent.
Does he make a direct payment or is that an income withholding order?
He comes in and makes the payment.
Thank you. All right, Mr. Lair, anything that you would like to say?
Yeah, I remember a while back we were here and I specified the way that I get paid, my payments will never be on time. So every time I make a payment, it's way more than I'm supposed to pay anyways. I asked and explained this time I had things come up. My mom had a heart attack. We lost our house for no reason. And there's no leniency or understanding in this. It's like, if I didn't know how to build a house, I wouldn't be hired for a job. Some of these people that deal with these cases sometimes don't know how to deal with them.
All right, I guess I don't, so how often do you get paid?
Sometimes I wait up to a month because people live out of state.
All right, well, if
The
you
job
paid
is-
monthly, if you paid monthly, then everything would be fine, correct?
Yes, and I specify this every time I make a payment. And I'm still taking care of my kids. I have a daughter that has a kid. I still take care of her. It's like sometimes life happens and that should be understood. Because I'd understand if I didn't get hired for a job that I don't know how to do.
All right, well, I mean, you're $1,600 behind, so it sounds like there's been some level of understanding, and I understand you made a recent payment. It was a decent amount, but we'll you need to keep track until you get yourself caught up. And there's
Yeah.
nothing owing and paying regularly.
I understand that. And for the last year, I've been paying for insurance for my son that hasn't been on state aid for this last 30 days. So should I be reimbursed for the last year of payments that he hasn't been on state aid?
You think there's some need for a new calculation, you're certainly free to request a new child support calculation. I don't know if that's not factored in or not, but you always have the right to, if there's a change in circumstances, you always have the right to seek a new calculation.
Yeah, I specified this the last time we were here, that he wasn't on state aid and it was
Again, you
on paper.
specifying things orally or not filing a motion. I don't know if you've been told to file a motion before, but that's the appropriate procedure. It's how we deal with matters in front of the court is we file a motion and then we have a hearing. So if you think it's appropriate to file a motion to address the current monthly amount that's ordered, you are certainly free to do that. So you're saying that the children are insured under your policy?
No, Luca was insured under his stepfather's for, I guess, previous months, but the last 30 days, Miss Owens has specified that she needed to put him back on, which is understandable and fine, but I just don't understand why I'm paying for insurance when he wasn't on insurance. Obviously, because there wasn't a paper filed.
Correct. All right. Miss Owens, anything that you'd like to say?
Just that, I mean, Tommy does try. He's not avoiding the courts or anything like that. I mean, people fall on hard times, and when he does make a payment, it's not like a $20 payment. He's making a chunk.
All right. All right. I mean, I also don't think it's a whole big burden to zoom in for a few minutes from home when there are issues with, the balance that is owed and payments. So I give you credit, sir, certainly for that recent payment. If you're getting a monthly payment in, then we don't have to see you. I'm going to adjourn you out a little bit just to make sure, you're staying on track.
Yeah, and I try to make it every 3 months at least. So I make the 3 months, the 62 plus I double the payment. So I pay like $360 every time I come in for the 3 months I'm behind. So that's a double payment every time.
And that would be great because then that would get you
It has
get
been
that
like
balance
that.
completely caught up. So I'm going to
Yeah.
adjourn you out. I'm going to set you for November 16th.
Okay.
If you're going to pop in and make one big payment, try and do it at least more than a week prior to the hearing, sir, okay?
I will, and I apologize. Like I said, my mother had a heart attack. Our house got given to a family member, so we had to move, and I specified this to her. And I understand that it was the paper that kind of reminded me, but sometimes we need a reminder. That's life.
All right. Well, if you can get that payment in, if you're current, you don't need to be here that day, but you got to get the payment in at least 7 days prior.
Okay,
Otherwise, we'll have you zoom back in, okay?
okay, thank you.
All right, you're all set.
All right, bye.
Matter of Ashley Bagby versus David Losvieski Sky, file number 14-15600 DP. Do we have the parties on that matter present?
Yes, Your Honor.
All right, sir, can you hear me okay?
I hear you, yep.
All right, thank you. And in front of the court, what is the status of this matter?
This is an arrears only obligation for the defendant with a current balance of $1,657.50. Last payment was received in April of 22 in the amount of $569.29. This is money that is owed to the non-parent custodian and some money that is owed to the state as well.
All right, thank you. Sir, what would you like to say?
Well, this was supposed to be taken care of when the friend of the court got, when everybody from the front of the court got let go and replaced. The lady who took over prior to Edward, when I was dealing with this matter, I was being charged way too much money, and the referee prior to yourself was not cooperative. He wouldn't let me contest anything. They were charging me for 65 hours a week that I was working instead of the 40 that I was actually working. And when I was dealing with the new friend of the court staff, the lady that was in charge told me that she would take care of it because it was obvious and blatant that I was being charged way too much. And it has nothing to do with Miss Bagby at all. It has to do with her mother, Sonia, who was the caretaker at the time. So her and I were dealing with custody issues at the time, and had nothing to do with Miss Bagby. But this was supposed to be taken care of back then. I didn't even realize this was an issue until my lawyer got a hold of me a few weeks ago and said that I was being called up for a show cause for old arrearages that I was told were going to be taken care of.
All right, well, what do you mean by taken care of? Somebody told you they're going to be wiped away?
Yes.
All right. And how is that communication? How'd that communication take place? Was that by email, phone call?
Phone call, yeah. And also in person when I came into the office. I came in and
How
sat
long ago are
down.
you saying that conversation took place?
I'm sorry?
How long ago are you saying that conversation took place?
That was prior to me getting custody of Brixton a few years back, so.
And you're saying that they had calculated your hours based on 65 hours of work that you weren't doing?
That I was not doing, right. I was working 40 hours, not 65. The lady who was in charge of the friend of the court at the time had a major problem with me for some reason. I never did anything wrong to that lady at all, but she hated me.
Did you file a formal motion to address the support amount or just had a conversation?
I filed a formal motion prior to the lady taking over, and I was basically, when I came into court in front of the referee, they both just dismissed me, wouldn't even talk to me about it. And that was when I was in person in the courtroom, in the right in front of the referee and the front of the court lady. They basically told me that, tough, you can't, they told me that I couldn't object to it. Which is that I found out is completely wrong. And the lady that took over the friend of the court, when that lady got fired, she told me that I should have been able to challenge that because I had all my pay stubs and everything that stated 40 hours, not 65, and I could prove that I was only working 40 hours. I had all that stuff in court, and she said that she could take care of it, but we had some major issues going on that made this look kind of minor, so I understand why it would have been forgotten.
What is your intent moving forward? You're saying you're not going to pay because you're under the understanding that you don't need to pay?
I don't believe that I should have to pay anything. I don't believe that I owe the money, and I don't believe that I should have been charged in the first place for 65 hours when I was working 40, and I gave sufficient evidence that I was working 40. My employer at the time sent in numerous copies of my hours, and it was just a personal thing that the lady had with me. I don't know what it was, but she wanted to just charge me for everything. She also constantly brought me into court for show causes and tried to get my license taken away. She tried to get me put in jail. She tried everything she could under the sun for some reason. I never
Are you
did
making any payment at all, or
What's that?
are you making any payment, or you just made no payments? Did you
I'm
make
sorry.
some payments? Did you make some payments? It's not the total amount?
No, I was making my payments were being taken out of my check until I got custody. Once I got custody, then the payments stopped, but
Correct.
I was under the impression that this was going to be taken care of. And I
You
wasn't
weren't
gonna,
making the monthly amount that was ordered? Is that what you're saying?
I was, yeah.
All right. I think we're talking two different languages, but what I'm gonna do is I'm gonna adjourn your matter out. I'm gonna pull your file and look through the whole thing.
Okay.
Try and figure out what you're saying happened and when. We'll see if there's any case notes. This was money owed to a third party
Yes.
while the child was party's
Sonia Wagner.
custody. I'm gonna take a look at the best I can for the information I can find in the files as to what you were ordered to pay, when payments were made, and those type of information. And we'll come back September 16th. I'll see what information I can find, and I'll still give you the right, if we need an evidentiary hearing or something on the matter, we can address that. So I'm gonna adjourn your case to September 16th. Any questions, sir?
Would you like me to come in person or do Zoom again?
No, these are all by Zoom.
Okay.
If you believe you have any sort of messages, emails on the subject, you're certainly free to get those and provide them to the front of the court in advance. Ms. Bagby, obviously this support matter doesn't involve payment to you. Do you have any questions or anything that you'd like to say?
I would like to say that I do believe David. He's absolutely correct as far as Francine Zisk and Scott Beatty. Our case got very, very confusing in 2022, and I myself was overpaying. My mother is the third party. Francine Zisk was ordered to abate my obligation because I was living with my mother, and she refused to do that for 2 years. So if Mr. Leshevsky says that Francine said she would help him and then she refused to, and then with the new friend of the court staff coming in, our case was very, very confusing, and I was living with my mother at the time. David was making his payments, and custody did change. I hope that you take into consideration my problems and frustrations with Scott Beatty and Francine Zisk too. She opened up multiple friend of the court payment cases towards me without proper information, trying to state that I had 3 different children when I only have 1. And our case did turn very messy because
Okay,
of.
so I will take a look at his matter. We'll come back
Okay.
October. I'll see what I
Yeah,
can find.
I absolutely
files.
believe everything that he's saying, and I don't believe he
All right.
owes anything.
Well, we'll see what was calculated at. We'll address that certainly on the 16th. I don't have all that information in front of me, so I will adjourn this out to give me a chance to take a look at all that information, okay?
Thank you, Your Honor.
All right, thank you both for appearing. You are free to sign off.
Thank you.
Thank you.
Alexandria Robeson versus Casey Leal, file number 25-20179 DC. Do we have either party on that matter present?
Yes, I'm here.
All right, good morning. Do we have the mother present in front of the court? What is the status of this matter?
The defendant has a monthly obligation of $432 and a current balance of $5,411. This is a relatively new case and no payments have been made. I did speak with Mr. Leal back on April 13th, and we discussed his options to potentially address some of his support concerns, and he has not followed through with any of those.
All right, thank you, ma'am. Anything that you would like to say?
No, I haven't been in any contact with him. So I don't really know if he's like even working or not.
All right, thank you. All right, well, given this failure to appear, I will recommend a bench warrant. Given that nothing's been paid, there's been zero effort, I'm gonna do a little bit higher than the minimum. So I'm gonna recommend a bench warrant. $2,700 plus $100 in costs. Any questions, ma'am?
No,
All right, thank you for appearing. You are free to sign off.
thank you.
Reports on the record, call the matter of Alex Yeoman versus Vanessa Smith, file number 16-16209 DC. Do we have the parties on that matter present? All right, Ms. Smith, can you hear me okay?
Yes, I can.
All right, Mr. Yeoman, if you could please unmute and start your video. All right, and can you hear me okay, sir?
Yes, Your Honor.
All right, thank you. So it looks like we're in front of the court based on a pairing time motion that was filed by mom, as well as then a ex parte motion that was denied, filed by mom, and then was referred to the front of the court. So Ms. Smith, what changes are you looking to make?
I'm looking to have our son at my apartment more. It was brought to my attention that there was some health hazards in the home, which is why I did the ex parte, and the doctor had also contacted CPS.
All right. Do you know what's currently going on with CPS or not?
It's still an open investigation. They're coming tomorrow to do a home visit for me.
Okay. All right, so you're asking to change the custody to the parenting time to what during the year?
With me during the school year, and then weekends for now as well until the mold is cleared up in the home.
What is the current parenting time work?
It's week on, week off in the summer, and I get him every weekend during the school year, and I get every holiday.
All right. You get him every weekend during the school year?
Yes.
You want to reverse that and have him go to dad's every other weekend during the school year?
Well, if every weekend, if he can, not at his dad's home because of the mold situation, though, because it's a health concern.
All right. Mr. Yeoman, anything you would like to say? Are you in agreement or not in agreement to making changes?
I'm not in agreement to the change.
Okay. Then what we would need to do is set the matter for a contested evidentiary hearing. That would be an in-person hearing. Those hearings are either 1 hour or 3 hours. Ms. Smith, do you have any thoughts on how much time you would need to present your case?
I have everything in order for what I need.
Are you going to have witnesses or your own testimony?
I will have my own testimony and a witness. Yeah.
All right. Do you think you'll have a witness from CPS or just someone else who knows information about the situation?
Probably CPS.
All right. And sir, do you think you would have any witnesses or just your own testimony?
Probably witnesses.
All right. Do you dispute what she's saying about the condition of your home?
The mold issue is we got mold in our bathroom right now, and that's the problem we're dealing with. Yeah, I kind of disagree a little bit. It's blown out of context or proportion. It's really not that bad. Yeah, I do need to address it's been an ongoing problem. I need to address the mold.
All right. Has CPS been to your home?
They were just here on Wednesday.
All right. Did they tell you that the child is not allowed to be there moving forward?
No.
All right. Did they tell you to address the mold situation?
Yes.
And what are you doing to do that?
Bleach, and then my sister works for ServPro, and she's gonna give me some botanical mold killer that they use.
Okay. All right, so if there's no agreement, what we need to do is set the matter for a hearing. My next available evidentiary hearing date is October 14th at 11 a.m. Do either of you have a conflict with that date?
No, Your
No.
Honor.
All right, so we'll set it for October 14th at 11. As indicated, that's an in-person hearing. You do need to file a witness and exhibit list if you intend to call any witnesses or file any exhibits. That needs to be filed 21 days prior to the hearing because the child will be 12 at the time of the hearing. He's certainly old enough for a preference interview. So he should be here at 10:45 that day. So whoever has the child that day needs to have him here at 10:45 for that preference interview. Any questions,
thank
Ms.
you.
Yeoman?
No, Your Honor.
Mr. Yeoman, sorry. Any questions, Ms. Smith?
No,
All right, thank you both for appearing. You are free to sign off.
thank you.
Thank you.
You have both parties present. This is set for a status conference after the parties went to mediation. Did the parties reach a resolution at mediation?
Yes, Your Honor.
I do see a mediation agreement that is attached showing the parties were there on Thursday, August 6th. So ma'am, do you agree that this mediation agreement resolves the issues? Ma'am, do you
Was that
agree that this,
right?
do you agree
Sorry,
that this mediation?
Yes.
Do you, all right. Do you agree that the mediation agreement resolves the issues?
Yes, sorry about that.
Thank you. I know with the lag, it sometimes get difficult and we go back and forth over each other. All right. And sir, you're also asking the court adopt that mediation agreement?
Yes.
All right. You are the plaintiff, sir. So I'll start with you first. Would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
All right. And so it looks like, sir, the mediation agreement indicates that you've reached a custody and parenting time agreement. You agree to joint legal custody. That mom will have primary physical custody of Serenity and that you will have primary physical custody of Mason. And you're going to let the children kind of decide where they go for parenting time. Is that correct?
Yes, Your Honor.
You also agree that for tax purposes, Serenity will be claimed by mom and Mason will be claimed by you. Is that correct?
Yes, Your Honor.
Do you believe this agreement is in the best interest of the children?
Yes, Your Honor.
Was there any discussion regarding child support?
We have to go back to the front of the court, and she told us to wait till we get the paper and then see what front of the court has to do.
Okay, so what we would do is we would do a new child support recommendation based on that arrangement. I think we would just do equal with each child since it's essentially one has one and one has the other. Okay. All right. Any other terms of the agreement that you think I missed, sir?
No, Your Honor.
All right, thank you. Ma'am, will you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And ma'am, you're also agreeing and ask the court enter an order that gives the two of you joint legal and joint physical custody of the two minor children. Is that correct?
Yeah.
I'm sorry, joint legal of the children, and then you have the primary physical of Serenity, and Dad has the primary physical of Mason, correct?
Correct.
Then there's not going to be any set parenting time. That'll be something that you guys have agreements and discussions with the children. Is that correct?
Yes.
And then you will claim Serenity, Dad will claim Mason for the tax deductions. Is that correct?
Yes.
And do you believe this agreement is in the best interest of your children?
Yes, I do.
Yep. All right, so we will make that change and then also prepare a new child support recommendation. You will have the opportunity to file an objection to that recommendation if you want to make some changes or don't disagree, or if you disagree with the recommendation. Any questions, sir?
No, Your Honor.
Any questions, ma'am?
No.
All right, thank you to both of you for getting together and working it through in mediation. We will send you out that new order. Thank you.
All right, thank you so much.
All right, thank you. So I will call the case of Cassidy Wheeler versus Slovano Southbird, file 2319253 DS. We do have the parties present here today on the other motion. Ms. Wheeler, what are you looking to change?
We are needing to get parenting time for our child to start school.
All right. Right now, your order is parenting time as the parties agree. Is that correct?
We are. I'm confused on the question. I put the draft in on what would be good for us.
My question was, your current order just says as the parties agree. Is that right?
Oh, yes.
No, I do not agree.
That is what it currently
All right,
says.
so hold on 2 seconds. So Mr. Southbird, you didn't really even answer the question, but no question was posed to you. I'm going to give you a chance to speak as well. What we don't do is interrupt the other party.
Sorry.
So Ms. Wheeler, what I'm looking at is, looks like there was a order back in 23 that gave the parties joint legal and physical custody and said parenting time would be as the parties agree.
Yes.
Is that your understanding of the last order?
Yes.
And what are you asking? Are you asking for a specific parenting time schedule now?
Yes.
And what schedule are you asking for?
I am currently, I haven't turned into the court, but I am asking for him to stay with me during school days. He can go with his father during the summer, winter break, Thanksgiving break, spring break, every other weekend. And during summertime, it'd be every other weekend with me and then just with him, and then except for alternating Christmas.
Okay. And Mr. Southbird, what is your position on that suggested schedule?
Well, my suggestion would be him stay with me for school year, and he can go with his mom 50-50 during the summer. If she wants him 50-50, if she wants him full time during the summer, that would be fine as well. We can do every other weekend for school time, and if she wants him during specific holidays during the school time, we can work out a deal with that as well. He has been attending Benogen. He graduated from Benogen here. He has a set of friends that he has made that are going forward to the next school where he would hopefully be going to.
All right, is he heading into kindergarten next?
Yes.
You're asking that he attends school over there with you, and Mom, you're asking that school's over with you, correct?
Yes.
All right. And Mr. Southbird, is there a reason I'm looking at either a wall or a ceiling and not seeing you?
Oh, sorry. I just had my phone set down.
All right, no problem.
But yeah.
Have you guys tried to discuss this and resolve it? I mean, doesn't school start everywhere in a couple of weeks here?
Yeah, yes, we have tried to discuss this 2 or 3 different times. Normally we can figure this out, but we have different ideas of what is better school.
We've got a problem because I don't have court hearings until October. So what are we going to do in September?
Well, he's sorry to interrupt. Okay. On my side, he's pretty much all set to go to Sutton's Bay schools. He's been going to schools here, like I said, for Benogen, and he does have a routine that we have in place for schooling.
All right, what have you guys, sir, what have you guys been doing for parenting time the last 6 months or a year?
We've been on 2 weeks on, 2 weeks off for the past, well, as long as this order has been put in place, this as parties agreed.
Is that correct, ma'am?
Yes, we have been we've been working really well together up until this point.
And how far apart do the two of you live roughly?
About 2 hours.
Yeah.
All right, well, I think next Wednesday, I have a case that was set for an evidentiary hearing, but is just going to be a stipulation. Do you think the two of you could be here next Wednesday so we could hold a hearing and the court can make a decision?
Because I have court for a different child. Let me look.
Otherwise, you're not gonna be in front of the court until October, and
I can make the sorry.
what is next Wednesday? What date is that?
the 26th.
I have court at August 25th.
All right, so if you could be here the 26th,
And it
we
wouldn't
could
be
take your
available because I have
case.
to be at court for a different child.
You could take your case at 1:30 on the 26th.
I can. Sorry.
And whoever has the child, because I have to do what's called a preference. Well, no, the child's only 5, so never mind. So you both can be here then next Wednesday, the 26th?
The 26th?
Yes,
Okay, sorry, I was breaking in and out.
no problem. I think you said your court date's the 25th,
Yes.
so could be here the 26th. Okay. So we will have you here next Wednesday at 1:30.
Okay.
Do you both waive notice to allow that hearing to happen that day?
Yes.
Yes.
Okay. I think it's the best move because you guys are in need of a decision before school starts.
Yes.
Right.
So we'll have about 3 hours for the hearing. So if you have a witness, you can bring a witness, or if you have exhibits, you can bring that information. I won't do a witness and exhibit list because we don't have enough time to do those things. That is an in-person evidentiary hearing, so I'll see you here next Wednesday, okay?
It's in person, you said?
Yes.
At the Stego Courthouse on Main Street?
Nope, at the other one over by the high school on Livingston Boulevard,
Okay.
where the front of the court is, yep.
In person.
All
So,
right, any questions, sir?
No, I'll be there.
Any questions?
nope.
Thank you both for appearing, and thank you both for accommodating the situation and agreeing to show up next Wednesday. Thank you.
Thank you.
Thank you.
All right, so ma'am, this is your motion, correct?
Correct.
All right, and what are you looking to change?
I would just like to maybe have something a little bit more set in
Good enough.
a schedule. Oh, there you go. He got it. And just so parenting time can be a little bit more fair.
All right, so it looks like you guys had a judgment of divorce back in October.
Correct.
It was joint legal custody, physical custody with dad, and parenting time as agreed, but you're asking for some type of specific parenting time schedule. Is that correct, ma'am?
Yes. She left in July of last year, and I saw her one week out of that year. So I understand that. What's that? Sorry.
Let's say by statute, a parent has a right to seek a specific parenting time schedule. So you certainly have that right. So the court can have a hearing on that issue. Or the parties, if they are able, could come to an agreement on what that would look like. Sir, what is your position on a specific parenting time schedule?
I don't have a problem with that. Our issue was school out here is year round, and so the scheduling is a little bit different with schooling. And when she came out here, she had transition problem from, obviously what everything was going on. And we worked through it. I got her into online school so that way we could have a more flexible schedule with her.
Okay. So ma'am, are you asking, I see in your motion, you mentioned equally shared time. Is that what you're asking for?
I'm not really asking for, I don't expect her to be out here 6 months out of the year because she is a teenager, she has friends, she has a boyfriend. I understand that, but I just wanted to I just want an effort to be made to have her be here more often. And I think Mr. Athey is willing to work with me on that. I just, there was a communication problem with speaking in a group chat with him and his girlfriend, and I didn't feel that that was necessary, that he and I should be able to discuss things about our child.
So one thing that you guys can do is I can refer you to mediation. That would be done by Zoom. So, given the distance, it wouldn't be an issue. You guys can meet with mediation, see if you can come to some type of schedule or agreement. You're not forced to come to an agreement. If you do, great. And that can become an order of the court. And if you can't, then you would have the right to come back and we would hold an evidentiary hearing and take testimony, and then I would make a recommended schedule. Would you be willing, and do you want to try mediation first, ma'am?
Yes, I would like to try mediation. I think that we could work through that very well.
Sir, are you willing to try mediation first?
Yeah, I don't have a problem with that.
Okay. I mean, it gives you both the most input and the most flexibility. So I think it's always good to try that first because, like I said, it gives you that flexibility with your schedules more than you would get with a court just simply making a decision for you. So I will refer your matter to mediation. We'll set a status conference out for a time after that mediation. And at that time, if you've reached an agreement, we'll make it a order. If you haven't reached an agreement, then we'll give you a hearing date to have an evidentiary hearing to address the parenting time. Any questions, ma'am?
No, sir.
Any questions, sir?
No.
All right, I just ask that you both give it a good faith effort to try and reach an agreement. And we'll see you back after that mediation. Thank you.
Thank you, Your Honor.
Thank you.
Do have Mr. Smith present as well now, so I will call the matter of Cody Smith versus Josephine Opperman, file number 14-15428DS. Mr. Smith, can you hear me okay?
Yes, I can.
All right, thank you. And sir, this is your motion, correct?
Correct.
And what are you looking to change?
Parenting time. Ms. Opperman and I have come with an agreement and would like to schedule mediation if that's possible.
All right, so you want to go to mediation or you have an official agreement?
We haven't sat down face to face and wrote anything down yet, and that's why we were wanting to schedule mediation.
All right, Ms. Opperman, are you agreeing to participate with mediation?
Well, if there's a way that we can just get it on record without mediation, I don't really see a reason in going to mediation.
All right, well, if you have everything covered, we can do it today, or if you think the two of you need to talk a little bit more, we can come back in about 30 days and do it.
I think if we can take care of it today, I'd rather do that than waste, time and money and stuff on mediation.
Right. What I'm saying is if you have it all today, we can do it. If not, you can agree to come back in 30 days and put it on the record to give you guys more time to make sure everything's there. So if you think you have the terms worked out, then we can do it today. If you need a little bit more time, I would just adjourn it out 30 days and then bring you back at that time.
I'm okay with doing it today.
Okay, yeah. There's just some things we didn't talk about, so that was, or come up with an agreement fully.
So we'll see how far we can get. If there are issues, then we may have to adjourn it out. So, sir, what's your understanding of what the change would be?
It'd be shared parenting time, starting Friday and ending on a Friday, week on, week off.
Okay, and that's throughout the year?
Yes, sir.
And do you have a holiday schedule that you follow?
Yes.
All right. Do you have a specific time that you would exchange on Fridays?
It'd be after school.
All right. When school's not in session, just at 3 p.m. or a different time?
3 p.m. works.
Okay. And if it's not getting the child from school, how would the exchange work? Do you guys meet somewhere? Does one of you go to the other person's house?
Yeah, we just do the non-receiving parent drops off.
All right. Any other terms that we have to address, sir?
I don't, no, sir.
Okay. And Ms. Opperman, do you agree to those terms?
Yes.
All right. Do you think there's anything else we need to address?
No.
I just would like to bring up one thing. So in our current order, it states, I think it's 63 or 4% of unpaid medical, would be, Mr. Smith would be responsible for that. And we had since talked and he had agreed to paying 70%. So I would like that in there somewhere as well.
What we'll do is we're going to do a whole new support recommendation. So that
Okay.
once that's done, if you guys want changes to it, you can file an objection and then we'll address it at that time.
Okay.
All right. All right. So, sir, I'll start with you. Would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And sir, is it correct that you're asking the court to enter a stipulated order that amends the pairing time in this case? The parties would have joint legal, joint physical custody. Pairing time would be week on, week off throughout the year. Exchanges on Friday after school or at 3 p.m. If there's a need for a drop off, the non-receiving parent would drop the child off. Is that correct?
That's correct.
And are you going to follow the holiday schedule that's currently a part of your order?
Yes, I think we were going to change a couple things on it, but nothing dramatic. It's nothing her and I can't work out without it.
Sure. So holidays will be pursuant
Yeah,
to that
we have
schedule.
a new we can get you a copy of the schedule that we were going to follow.
Okay, so I'll say that holidays are going to be as the
So that
parties.
just so that it's in there.
The parties. So, sir, you agree you're going to submit a new holiday schedule?
Yes, sir.
And you believe this agreement, sir, is in the best interest of your child?
Yes, sir.
Thank you. Ms. Opperman, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And ma'am, you're also agreeing to this change. Parties would have joint legal, joint physical custody, and pairing time would be week on, week off. Exchanges on Friday. Is that correct?
Yes.
And the two of you are going to submit a new holiday schedule to the court. That'll be the schedule that the two of you agree to. Is that correct?
Yes.
And do you believe this agreement is in the best interest of your child?
Yes.
Okay. All right. So we will prepare that paperwork. As indicated, there will be a new support recommendation that's prepared. Both of you or either one of you will have the right to file an objection to that recommendation if you want to seek some type of changes or you have objections to the information inside of the report. Any questions, sir?
No, sir.
Any questions, ma'am?
No.
All right. Thank you both for appearing and thank you for working together. You are free to sign off.
Thank you.
Thank you.
All right. So we're here today. It looks like on a pairing time motion filed by Mr. Brandow. Mr. Brandow, what are you looking to change?
It's not really changed. It's just last few times I've been trying to pick my kid up. She just basically told me I'm not getting her, and I called the cops, had them come there. I've had her dad come out to my house trying to fight me. It's just been messy, and I'm just over getting just thrown. Like, she just does what she wants to do. Court order don't mean nothing to her.
All right. Well, that's really more of a parenting time complaint or violation. Have you missed parenting time?
Yeah,
All right. Is your parenting time happening now or not happening?
it happened last week. I'm supposed to get her today.
All right. And I know we have a hearing coming up in September, correct?
Yes, sir.
All right. Ms. Kapanke, anything that you want to say on this issue?
Yes. So the day that I was supposed to drop Amani off, I was out getting my car looked at. So I was running a few minutes late. So I didn't text, and I should have. That's where I went wrong. and I asked him if I could bring her out to him. He starts cussing me out. So I'm like, well, I don't understand why this is an issue. I thought it was his wife writing me. So I kept telling him to unblock me so I can write him and communicate with him. I only want to communicate with him. I always have to communicate through his wife. We always seem to disagree. So I kept asking him to unblock me, unblock me, unblock me. He wouldn't. So I ended up telling him I would bring her out to him. There's multiple times where I've had to pick her up from his mom's. I've had to pick her up from his wife's sister's house. I've had to drive to Midland to pick her up on his day. I've had to drive her to her soccer game when their car was broke.
Moving forward, Ms. Kapanke, you agree there's an order and you're going to follow that order until it's changed, correct?
Absolutely.
All right. So what I'm going to do is, this really isn't a parenting time motion. So Mr. Brandow, if you want to file a parenting time complaint, you'll need to file that with the friend of the court. So if you're saying there's missed parenting time and you want make up parenting time, then we need to go through that procedure. But that is something we can also address. If you do file parenting time complaints, we can address that at our upcoming hearing to address the other matter. So the parenting time motion itself is dismissed because you're not really requesting to change parenting time. It's a parenting time complaint. If you want to pursue those matters further, you need to file the appropriate parenting time complaint. And if that is filed, we'll address that issue at our next hearing. Any questions, Mr. Brandow?
No, sir.
I have a question.
Yes.
Sorry. So when I talked to somebody up there, they said that there's an app that me and him can communicate through. How do I go about getting that app so I don't have to text his phone? He doesn't have to text mine. It can go through that.
There are different apps that parents can communicate through. There's Our Family Wizard, there's App Close, and there is a fee associated with that, but certainly parties are able to communicate through those. If you guys want to agree to do that, you can. I'm not going to order it today, but I will certainly consider something like that when we come to court next time if you want to raise that matter. You guys can have discussions before then. If you reach an agreement, great. If not, that's something we can also address at the next hearing.
Okay, thank you.
All right, until then, just make sure you both are following the order, and I'll see you at our next hearing in September. Thank you.
Okay.
Thank you.
Jenowick versus Andrew Tinsley, file number 26-20410DN. Do we have parties on that matter present?
Yes, Your Honor.
All right, looks like we have a hearing coming up on September 16th. But plaintiff has filed a motion to dismiss the defendant's motion.
That's correct, Your Honor.
Wise, what would you like to say regarding your motion?
So on September 16th, we are scheduled for my client's motion to change domicile to move the children's residence while in her care to Wisconsin. In response to that, defendant filed a response, but also filed a motion to modify custody, parenting time, and support to have the children moved to Maryland, which is where he resides. I do not believe that that motion is supported by change of circumstances or by proper cause and should be dismissed prior to an evidentiary hearing. However, Your Honor, I received a phone call this morning from opposing counsel, and it looks like we are close to a resolution as to all pending matters, including having the children move to Wisconsin with a very small tweak to parenting time. We're just not there today. Opposing counsel and I were curious if Your Honor would be able to squeeze us in for this hearing in a week or two prior to that September 16th date if we agreed to adjourn it and explore that resolution and not have to hold the hearing today.
Well, I don't think I could squeeze you in, but certainly you have the ability to re-raise any proper cause or change of circumstances at that hearing. However, I think when you look at the case of Selke versus Vandermas, 268 Mishap 262, a change in legal residence in excess of 100 miles is a change of circumstances sufficient to reopen a custody matter. So if your client's looking to move and that move's granted, I think there's also, she's moving, there's an argument that he has a right to make a request to change custody. Obviously, he still has to come over those hurdles of established custodial environments and clear and convincing evidence and those things, but I'm unlikely to dismiss his complaint if I'm granting a move for your client.
So, Your Honor, I completely understand that point and understand that case law. I guess my position is that this motion is premature because Your Honor has not made a decision as to the change of domicile to Wisconsin. And so that change has not occurred. There's nothing about my client requesting a move that would sustain that level of, proof that there is proper cause or change of
If your
circumstances.
client's move got denied, then they would have to make arguments a different argument as to why there's proper cause or change of circumstances.
Right.
But if I grant your motion that day, I'm not gonna make them come back a whole separate day. We've got 3 hours, we've got time to do it all.
Well, Your
Okay.
Honor, I guess my concern with that is that this motion that defendant has filed is completely comprised of old allegations. There's one new allegation, which is untrue, and I've talked to the counselor. The counselor appeared today to provide limited testimony to that extent. I guess I would ask for
We don't
clarity.
take testimony on these days either. So what I'm gonna do is I'm not gonna deny your motion. I'm gonna adjourn it out to the date of our hearing. All those issues can be re-raised that day. If the two of you said you're close to some type of agreement. So if you guys do reach an agreement before that hearing date, you can appear by Zoom to put the agreement on the record, but you would need to make sure in advance that you submit to the court the agreement signed by everybody. If that's the case, you wouldn't have to be here that day. You could appear by Zoom and we could take the best interest testimony and the stipulation testimony. So if you do reach that, you can do it that way. If not, everybody here in person on that date. Any other questions, Ms. Wise?
Your Honor, and this is stated with full due respect, I'm just trying to understand the court standard in terms of that preponderance of the evidence of showing whether an evidentiary hearing is even necessary. And the only reason I'm pressing that, Your Honor, is because if I have to prepare to defend against that motion, it greatly increases the cost to both parties. It greatly increases the scope of the court's inquiry. It requires a lot more professional, medical professionals to disrupt their schedules to come in to testify because we're talking about changing an established custodial environment. So the scope is so much bigger.
I made my decision. I'm not denying it. I'm reserving it. And if there's a request to move more than 100 miles and move out of state, I'm certainly going to give a party the opportunity, if that move is granted, to argue that perhaps custody should be changed. All right.
Understood, Your Honor. Thank you.
Mr. Moser,
Your
is there
Honor,
anything you'd like to say?
Yes, thank you, Your Honor. I understand the court's ruling for purposes of today, and I do agree with counsel that we were very close to the potential for a resolution. In fact, I'm going to draft something to circulate to her because I'm going to be optimistic. But my question for the court is, I thought I heard you say that if we do end up reaching an agreement, we need to put that on the record, or am I misunderstanding? Normally, we would just submit it to the court, maybe the front of the court, or Your Honor would approve it, and then would be submitted to the judge for signature. Are you saying that we would need to come put all that on the record?
Yes, just real brief testimony. Otsego County likes to handle it that way, so we would just have everybody zoom in. I'd put your clients under oath just to make sure they're agreeing to all those terms.
Okay,
But
fair enough.
Okay,
I haven't done that way before, but I get it. So, okay, thank you.
All right.
That's all I had.
Thank you.
All right.
Thank you both for appearing. I'll either see you in person or by Zoom on the 16th of September. Thank you.
Sounds good. Thank you.